morning, everyone. Good morning, Mr. Gladhill. Lord Justice Arnold, you can hear us?
I can indeed, thank you.
Thank you. Please, Mr. Gladhill, continue.
My lady and my lords, we were talking about ground 2. We were in ground 2, and the claim that fiduciary duties or a duty of good faith arises out of the exclusivity agreement, so-called exclusivity agreement. That is pleaded at core 16, page 376. If we could go there, please. And the relevant bit of the pleading starts at page 376, paragraph 26, where it says, on 22 May 2014, Mr. Walmsley gave the required confirmations and so agreed that with immediate effect, the Lohomij Group and Bonhams had exclusivity over the proposed transaction and would cease all negotiations with RM, defined as the exclusivity agreement. Then it goes on further. The terms of the agreement between Bonhams, Lohomij Group and MRL were substantially the same as those agreed with RM, namely, and it's listed 1, 2, 3, 4, said to be binding terms of the exclusivity agreement that Bonhams would purchase, Bonhams would auction, etc., etc. And then at 28, by insisting on exclusivity, Bonhams specifically required MRL to stop negotiations with RM, so MRL was in practice committed to contract with Bonhams or lose the deposit. In the circumstances, Bonhams owed MRL a fiduciary duty to act in the best interests of MRL as their agents for the transaction and or to obtain the best price for the collection. And then skipping to the end, further or alternatively, Bonhams owed MRL a duty of good faith. Now, the point of reminding you about that is that's the beginning and the end of the pleading as to how the duties arise, alleged duties, and they are based purely on the email of the 22nd of May, or the email exchange. And I read that yesterday, won't repeat it. It's clear that any agreement by Bonhams to act in relation to the collection is in fact subject to contract and further investigation, contrary to what is said here. Paragraph 26, sub 1 to 4 are not in fact binding legal obligations, and we say nor actually is the exclusivity obligation, but that point doesn't matter because there's no breach of that alleged. So the point is that the alleged fiduciary duty or duty of good faith arises or doesn't arise, as at the 22nd of May, from this email exchange, or it doesn't arise. And it, in particular, doesn't arise from later facts that Mr. Fenwick was suggesting that are not pleaded, such as Bonhams later taking possession of certain cars and making preparations for auction, because that is not relied on in the pleading as the basis for the agreement. So the criticism made of the judge about getting into contested facts or there not having been disclosure and doing things in advance of disclosure goes nowhere, because to determine the existence of these duties, all the judge had to do, and indeed all the judge was allowed to do, was look at the pleaded basis for it, which was an email. And that's what he did.
And this is the draft amended particulars of claim?
Yes. But in this respect, apart from paragraph 27, it's the same as the particulars. But yeah, that's the only pleading.
This is sorry. The point I was suggesting is this is the last word on it. It's the up-to-date word.
Yes. What you have here is the draft amended particulars, and that's what was being debated at the first instance. So Bonhams did not assume any legal obligation to act in relation to the collection until the commercial agreement was signed at the end of June. And at all times until then, whatever anyone's working assumption or expectation or hope might have been, the fact is that Bonhams had not agreed to auction the cars, and the parties were negotiating whether Bonhams would, and if so, on what terms. The judge found that the email that I read yesterday, of the 22nd of March, clearly did not create a contract binding on Bonhams to buy the collection and sell it on as alleged at 26 sub 1 to 4. And we can see what the judge said and found in the judgment at paragraph 126, core 11253. So at page 253, at the top of this page, we can see the bold heading, Pre-Settlement Agreement Causes of Action, subheading, Claim against Bonhams for breach of the exclusivity agreement. And the judge starts at 126 and 127, 128 by considering whether there is in fact an exclusivity agreement. So at 127, first, although MRL describes the alleged agreement as an exclusivity agreement, the case it advances regarding breach has nothing to do with exclusivity, but with the commercial terms on which Bonhams would act in respect to the acquisition and sale of the collection. However, the 22 May email cannot reasonably be construed as evincing an intention to create legal relations in respect of the acquisition and sale of the collection. The email twice makes it clear expressly that the agreement is subject to contract, and it envisages that there will be a due diligence process before the agreement is finalised. I won't read the rest of the paragraph. At 128, if the 22 May email gave rise to any legal relations, it did so only in respect of an exclusivity obligation, whereby MRL was bound not to negotiate with third parties in respect of the sale of the collection. I think it doubtful whether there was sufficient certainty in respect to the duration of any period of exclusivity. However, no breach of exclusivity is alleged. And you might think that the judge was being a bit tough-minded about sufficient certainty because of the absence of a time obligation, but as we'll see shortly, he had House of Lords authority back him up on that point. So that's the discussion of whether there was an exclusivity agreement at all. Then his analysis of the fiduciary duty claim starts at 135 at page 257. And at 135, the judge correctly states what the pleaded allegation is, that by reason of the exclusivity agreement and MRL's consequent termination negotiations with third parties, Bonhams owed to MRL a fiduciary duty and or a duty to negotiate in good faith. And then under the italicized heading fiduciary duty, there is his discussion of whether a fiduciary duty arises. And much of this was read to you yesterday, so I won't reread it, but I'm just identifying again where it is. The conclusion is at 136, plain, no fiduciary duty. Mothview is cited, as almost always is in this context. The only point I would emphasise in the quotation from Mothview is the first line, a fiduciary is someone who has undertaken. The point is that the fiduciary has to agree to act in that regard. And you can see the same word in the quotation at the bottom of this page, the double quotation. It's from the Al Nahayan case, Lord Justice Leggett, 159 Al Nahayan. Fiduciary duties typically arise where one person undertakes. That's the key point. This stuff is all pretty orthodox, and I'm not going to read it out. Indeed, much of it was read to you yesterday, but it's the word undertaken, undertakes, and then over the page in the quotation at 259, within paragraph 41, 5 lines from the bottom, founded on the acceptance. And that's the only point that I'm trying to draw from it, that the fiduciary isn't a fiduciary until he accepts or undertakes in some way by words or acts to act. And then at 139, as Mr. Toledano, who was doing my job, submitted, prior to the making of the commercial agreement, MRL and Bonhams were in negotiations as to whether, if so, on what terms Bonhams would act in the sale of the collection. Their relationship was one of commercial parties, each acting and entitled to act in his own interests. And that really is the judge's analysis of fiduciary duty. I suggest that it's clearly correct. I don't really have anything useful to add. I don't think anything would be gained by me going through the authorities on fiduciary duty. The judge has done that. We agree respectfully with him. And the short point is you're not a fiduciary until you've agreed to be one. And as at the 25th of May 2014, which is the extent of the pleaded basis for the fiduciary relationship, there clearly was no agreement or acceptance of such a role by Bonhams. So that is what I have to say about fiduciary duty. Turn then to the other aspect of ground 2, which is good faith. And the short point is that no duty of good faith exists between parties engaged in adversarial negotiations about whether to enter into a contract and on what terms. And that is the position here. After the 22 May email, Bonhams and Lohomij are going to receive the required documents, the information that they say they need to look at. They're going to consider it, and the parties are going to see whether they can agree a contract. So Bonhams and Lohomij on the one hand and MRL on the other are in adversarial positions. They're engaged in negotiations. And the short point is that English law does not recognise a duty of good faith between adversaries in negotiations. See Walford and Miles, which is, I think, the only case I'm going to go to. It's in Authorities Bundle 3, tab 29. This was a House of Lords case about negotiations for the purchase of a photographic processing company. Lord Ackner gave the only speech, or only substantive speech. The others all agreed with him. The key passage is at page 138, just above C. And if I pick it up 3 lines above C, while accepting that an agreement to agree is not an enforceable contract, the Court of Appeal appears to have proceeded on the basis that an agreement to negotiate in good faith is synonymous with an agreement to use best endeavours, and as the latter is enforceable, so is the former. That appears to me, with respect, to be an unsustainable proposition. The reason why an agreement to negotiate, like an agreement to agree, is unenforceable is simply because it lacks the necessary certainty. The same does not apply to an agreement to use best endeavours. This uncertainty is demonstrated in the instant case by the provision which it is said has to be implied in the agreement for the determination of the negotiations. How can a court be expected to decide whether, subjectively, a proper reason existed for the termination of the negotiations? The answer suggested depends on whether the negotiations have been determined in good faith. However, the concept of duty to carry on negotiations in good faith is inherently repugnant to the adversarial, gosh, that's a rare thing, typo in a reported Lord's case. Anyway, adversarial position of the parties when involved in negotiations. Each party to negotiations is entitled to pursue his or her own interest so long as he avoids making misrepresentations. To advance that interest, he must be entitled, if he thinks it appropriate, to threaten to withdraw from further negotiations, or to withdraw in fact, in the hope that the opposite party may seek to reopen the negotiations by offering him improved terms. Mr. Norton, of course, accepts that the agreement upon which he relies does not contain a duty to complete the negotiations, but that still leaves the vital question. How is a vendor ever to know that he is entitled to withdraw from further negotiations? How is the court to police such an agreement? The duty to negotiate in good faith is as unworkable in practice as it is inherently inconsistent with the position of a negotiating party. So that's what the House of Lords unanimously said. That was 30 years ago. It's still the law. That's really the end of the duty of good faith. I will show you over the page at 139 what he says about the enforceability of lockout or exclusivity agreements. Just above D, there is clearly no reason in the English contract law why A, for good consideration, should not achieve an enforceable agreement whereby B agrees for a specified period of time not to negotiate with anyone except A in relation to the sale of his property. The key words being a specified period of time, and that is obviously what the judge had in mind, paragraph 128, when he said that the exclusivity agreement, when he doubted it, he didn't have to decide it actually, but he doubted that that was a binding obligation. And it's obviously this passage of Walford and Miles that he has in mind, because the House of Lords is saying that, yes, lockout or exclusivity agreements can be enforceable if they're for a specified period of time, but not if the time period is left uncertain. And you can, I won't read the rest of it, but relevant to that point is really the rest of this down to 140, just above D. Lord Ackner rejects the possibility that you can imply a reasonable period of time to supply the absence of an express stipulation as to time. He says that doesn't work for reasons he's given. But I don't need to get into that in any detail. I'm just identifying why it is that you might think that the judge was quite tough-minded at 128. Well, that's probably why he read that bit of Walford and Miles. But the point about whether the exclusivity obligation is binding is strictly neither here nor there, because there's no breach of it. Anyway, upshot, I submit, judge's conclusion that there was no duty of good faith in this situation was correct. I emphasise that none of ground 2 matters if MRL have not also succeeded on ground 1, which is why I've taken it fairly briefly. I would now propose to go to grounds 3 and 4. And can we take up the grounds, please, at Core Bundle, tab 1, page 32. So grounds 1 and 2 I've dealt with. Ground 3 is that by reason of the error in ground 2, the judge was wrong about deciding breach of fiduciary duty in good faith. But we've been arguing this really on the duty point, not the breach. I understand MRL to accept that the freestanding claim, a freestanding claim to breach of fiduciary duty or breach of duty of good faith would have gone with a settlement agreement. Its only purpose of the only purpose of trying to resurrect it is so it can act as unlawful means for the purposes of the conspiracy. We don't really have anything to add to what's in our skeleton, which isn't much, about ground 3, because we're debating really the existence of the duty or not under ground 2. Ground 4, then, they say, by reason of the errors addressed in grounds 1 to 3, the judge was wrong to decide that MRL's claim of conspiracy was not reasonably arguable. That's not completely right. If the conspiracy claim survives the settlement agreement, it would only survive in very significantly abridged form, because a lot of the alleged unlawful means were disposed of by the judge and have not been appealed. The only ones that have been appealed are the ones in grounds 2 and 3. MRL have to win on ground 1 and 2 for the conspiracy claim to work. I've said ground 2 is trying to resurrect the unlawful means, and if MRL don't win on ground 2, they've got no unlawful means for the conspiracy claim, and they lose anyway, even if we're wrong about the settlement. Anyway, I'll go to ground 5 now, please, and I think in the light of yesterday I can take this pretty shortly as well. Ground 5 only concerns one of my lay clients, B and B. It says the judge was wrong to decide that the claim against B and B for breach of fiduciary duty in the conduct of the auction was barred by the Californian law of limitation. And we had understood that to be an attack on the judge's finding that the claim against B and B was time barred under the Californian law of limitation. But I don't think actually that attack is being made. The claim, just I'll identify what it is, because otherwise it's confusing. I don't think there's a lot of sort of argument by me to be done, but I might as well identify what the issues are and why I think they've gone away, because otherwise you'll go away and potentially get confused by it, or maybe not. So the claim that we're talking about here is particular as a claim, para 128 at 401, so it's core 16, page 401. So it's 128 is the only relevant paragraph. It's further, Mr. Brooks, Bonham's or B&B's conduct of the auction was deliberately designed to harm MRL and so amounted to a deliberate breach of fiduciary duty. And then there are 12 particulars of breach. And the short point that this claim actually only affected B&B, because it was B&B in America that conducted the auction. And that claim for breach of fiduciary duty was governed by Californian law, because there was a Californian law contract that applied. And our point was that this claim at 128 was gone as a freestanding claim for limitation reasons, the limitation law being the law of California. We did not plead.
Mr. Clayton, could I just ask a question here? I don't understand it to be in dispute. But nevertheless, I'm a little puzzled myself as to why Californian law applies, and I could therefore be grateful for a short explanation of that.
Yes, my lord, it applies because this was common ground, but it applies because the consignment agreement under which the cars went to B&B, that 10 cars that were auctioned in California, was governed by California law.
To be sure, I've understood that, but what that would lead to was a conclusion that any claim for breach of contract under that agreement would be covered by Californian law. Why does it also lead to the conclusion that the alleged breach of fiduciary duty is subject to Californian law?
Well, the short answer, and I hope I'll have a better answer in a moment, is that I think we said it was governed by Californian law, and that was common ground. So I haven't had to think about it, which is not a legally satisfying answer, but that's the true answer for present purposes. I'll see if Mr.
But
Butler
on
can
the other
improve.
hand, it's not the court's job to inquire into issues which are common ground between the parties. I would just be puzzled there.
Yes. Well, I'm going to see if Mr. Butler can do some work on that and see if we have a better answer in a moment. We were saying, anyway, that this claim at 128, as a freestanding claim, had gone because it was time barred in California. But importantly, what we were not saying is that the conspiracy claim that relied on these particulars was time barred. That wasn't a limitation plea we were making. So it wasn't something the judge had to consider, it wasn't part of the application. So the narrow point here was, if this was going to be a freestanding claim, did it not work because of time bar? And I don't think that MRL are challenging the fact that it has gone as a freestanding claim. And if that's right, there's nothing between us. The problem is that we had read the grounds of appeal as trying to resurrect paragraph 128 as a freestanding claim. And if that were the appeal, we'd have much to say about it. But I don't think it is the appeal, because actually, listening to Mr. Fenwick yesterday, he wasn't saying anything about California law of limitation, and I don't think that was where he was going. But in case I'm wrong, the judge dealt with this, and I'll just show it to you, not argue it, because I don't think there's any point in arguing it. The judge dealt with this at paragraph 153, core tab 11, 264. And just to identify it, not to argue it, 153 is where he addresses it, and he records that the state of California law applies, and at 2, the parties were in agreement that the relevant law is that of the state of California and was substantially agreed as to what the law was. He summarises the pretty much agreed expert evidence on the point at 3, and then at 4, this was actually read to you yesterday, and I think Mr. Fenwick's point is that that didn't really answer his point, and it may not have answered his point, but the point that the judge and we are on is the California law of limitation. And what the judge essentially is saying in that sub-paragraph is that the points that were being relied on at 128, the particulars at 1 to 12 at paragraph 128, the particulars of claim, those points, the facts there, were necessarily known to MRL because they were complaints about the public conduct of an auction that Mr. Sullivan himself was at, or MRL knew about them as evidenced by the letter before action, because the letter before action refers to them. And I don't think the contrary is being argued, but if it is, the references are in our skeleton at paragraph 61, 65. And I think it would be a waste of time to go through them properly, but they're all there, and I've identified what the scope of the argument was. So that takes...
The relationship between B&B and MRL arose by and only by the consignment agreement. Is that right?
I believe so. Yes.
So that would mean that any fiduciary duty which arose would also be governed by US law.
Well, that's Lord Justice Arnold's point. I believe so, but
I can't see how it wouldn't, because they had no relationship until the agreement, which expressly provides that the relationship should be governed by the laws of the state of California.
yeah. Well, I'm accepting it because it's common ground. It's not something I've drilled into, but that would be my belief. Yes.
Thank you.
Yeah, but the problem then is how does the fiduciary duty arise in the first place? Because if that analysis is correct, then the first question is whether there's any fiduciary duty as a matter of Californian law. And that was all argued by reference to English law, hence my puzzlement. But I don't think any of this matters.
But my question is, was it? Because I think that the judge proceeded on expert evidence, and I thought that expert evidence was expert evidence of Californian law and fiduciary duties in relation to Californian law.
Yes.
So I think that the issue that is troubling Lord Justice Arnold does not necessarily arise.
Well, my lady, it may arise, but it was, I think, dealt with in the California law evidence. As I recall, it was common ground between the Californian lawyers that a fiduciary duty arose.
Ah, well, that's the bit of the jigsaw puzzle I was missing. Okay, thank you for that. That's helpful.
Well, it hasn't been very helpful, I'm afraid.
No. Thank you for placing my piece of the jigsaw in Lord Justice Arnold's jigsaw.
If anyone does want to look at it, the California law evidence is supplemental bundle 20, 21 and 28. I haven't prepared any submissions about it because there wasn't really any dispute about it and hasn't arisen on the appeal, but that's where it is, that's the background.
Thank you.
So, could we please get the grounds open again to turn to ground 6? So this is core 1, page 32.
This is the mini trial point.
Yes. Ground 6 concerns the post-settlement causes of action. And it's said that there was an impermissible mini-trial and findings of fact were made based on an incomplete documentary record, etc. In consequences, the judge erred in, and then Romans 1 to 4, in making findings which were not properly open to him to make in respect to the post-settlement agreement causes of action. Well, I'll comment as I go through. This is hopeless as a ground of appeal because it doesn't identify what findings of fact the judge made that shouldn't have been made. It's just impossibly vague. If you're responding to this, well, I've written in my own notes that, which, question mark, wholly vague. And it's impossible to respond to this. I mean, this matters because you can't respond to it more sensibly than by saying, no, he didn't. You can't take the debate any further. So it's not a proper ground of appeal at all. 2 and 3...
Well, can I just ask a question about that? I understand the point you're making, but the high-level ground of appeal, and I appreciate your response is the same, is look at the judgment. When it comes to the post-settlement agreement causes of action, there's more than 170 paragraphs. It looks and feels like a trial judgment, and when you read through those 170 paragraphs, it looks even more like a trial judgment. Because in reality, what the judge is doing is assessing claims on the basis of the material before him. So that's the high-level complaint. And I appreciate you say, well, you've got to descend into particularity. But why is there not something in that high-level complaint?
Well, the judge, no doubt, well, he definitely did get stuck in. I mean, it's very long, it's very detailed, it's very thorough. But you do have to ask yourself, has he impermissibly made any finding of fact that mattered to the result, that affected the result? And actually, when you go through it, you see that he's crunching through the material, got fully aware in his mind of what a mini trial is, what the exercise is and permissibly is, and he's just looking at the allegations and seeing if they work to the summary judgment or the strikeout standard. And just because, gosh, it's terribly long, that doesn't mean that you don't have to identify some finding of fact that mattered to the result that affected the analysis. And it doesn't make the ground of appeal at Roman 1 work. You've got to identify a finding of fact that shouldn't have been made that mattered. And that's what hasn't been done, and it can't actually be done, because actually when you crunch through, and it is very long, the back end of the judgment, you crunch through the post-settlement causes of action, they are rejected for numerous independent reasons, but none of them on analysis involve making findings of fact on contested evidence. They just don't. And they're rejected for numerous independent reasons, none of which actually do the impermissible mini-trial thing. Because it's so long, you can stand back from the thing and assert, gosh, it looks like a trial judgment, that must be a wrong thing to do. But you've got to actually read through it and see, has he done anything wrong? And if you do that, he hasn't. Well, because this point has been made, I will make the rather trite point that grounds of appeal are required to identify the specific errors which the judge is said to have made. This is trite stuff, but references Taylor, 2020 Business Law Report, 1486, paragraph 68, Lord Justice Underhill, agreeing with Lord Justice Arnold, actually, on that. And the Court of Appeal's jurisdiction is constrained by the scope of the grounds of appeal and of the permission which has been granted. Reference there, Hickey, 2018, 4 Weekly, 71. See the head note, see para 74. The Court of Appeal, all members agreeing. So grounds do matter. I mean, that's trite in the Court of Appeal. And these grounds don't state any intelligible appeal against my clients at all. And Roman 1 doesn't state any intelligible appeal against anyone. Romans 2 and 3 don't concern me directly. They concern Lohomij. I think I'm accused, or one of my clients is accused of having procured one of the breaches, but I'll just rely on what Mr. Colton has to say about whether there were breaches or what he says about these grounds. And 4 is a complaint about the dismissal of the amendment application, but if you look at it, that also concerns Lohomij only. That's draft amended particulars 134. So as regards the Bonham's defendants and Mr. Knight, ground 6 doesn't state any valid or intelligible ground of appeal against my clients. And it follows from that that no permission has been given for any appeal under ground 6 against my clients. And the failure to state the ground of appeal in the grounds can't be fixed in the skeleton. The point of the skeleton, obviously, and this is trite, is to state the reasons in support of the grounds, not the grounds. I don't think I'm wrong about that, but if I'm wrong about that, one can turn to the skeleton and just see what grounds they try to develop. So this is core tab 2, page 58. And the bold heading above 85 is ground 6, and then the complaints are, well, paras 86 and 87 are complaints about not paying enough attention to MRL's evidence about the sales. 86 concerns Lohomij, nothing to do with me. Paragraph 87 is just wholly generic and high level. There's no attempt to analyse or identify or make good any specific error. Paras 88 to 93 primarily concern Lohomij, and the second respondent and Mr. Knight is only indirectly concerned because they're accused of procuring, so I'll leave that to Mr. Colton. Paragraph 94 is the only thing that conceivably concerns me. It said that finally the judge simply did not address the involvement of Mr. Knight and his involvement in providing fluctuations which fluctuated wildly. Well, as we've seen, that doesn't relate to anything said in the grounds of appeal, so you can ignore that. It's not part of this appeal. In fairness, Mr. Fenwick didn't address paragraph 94 orally. You won't find any mention of Mr. Knight in what he said orally. So I suppose it follows logically from that I've got nothing to add because I've already commented on what was in his skeleton, in my skeleton, at paragraph 71. If you want to track it down, it's paragraph 71 of my skeleton responding to their skeleton on that point. But this just isn't developed. It said that the judge didn't address the involvement of Mr. Knight. That's just wrong, because he did. See judgment paragraphs 312 to 313, 327 to 328, 350 to 351. So he did address the involvement of Mr. Knight to the extent that he had to the extent that Mr. Knight's alleged valuations had anything to do with the claims that were being run. And just, I think what this paragraph is about is that in the judgment, well, they actually say, see para 356 of the judgment. If you go to para 356 of the judgment, at page 342, core 11, 342, judge says, I don't propose to make an already prolix judgment even longer by analysing the details of the valuations given or said to have been given at various times by Mr. Knight. Well, he didn't have to get into any allegations about the valuations to the extent that he hadn't already dealt with them, but he had already dealt with them. And the ones that he didn't expressly have to deal with were these sort of slightly odd free-floating allegations in the middle of the particular claim that don't go anywhere. And you can see that there are particulars of claim, which is tab 16, 394. There's an italics heading, Mr. Knight's valuations of the collection. And at 108, it said Mr. Knight's valuations of the cars fluctuated radically. And there's an Annex 1 referred to. This is all part of the factual background section, not the causes of action section. The causes of action section picked up some of the valuations at paras 132 and 135, and to the extent that the judge had to deal with them, he did. What he didn't deal with was the freestanding bit at 107 and 108, and that's because he didn't have to do his job.
Gretel, can I just ask you this? I think as Lord Justice Arnold was effectively raising with you, it seems to me it's a perfectly legitimate ground of appeal to say the judge conducted a mini-trial when he should not have done so. It's well recognised in the authorities that a judge shouldn't do that. That's the ground of appeal, and Lord Justice Arnold granted permission. So it seems to me that's a complete and coherent ground of appeal which has been advanced and which you have to respond to. As I understand what the 1 to 4 are saying, well, because he conducted a mini-trial on incomplete documentary record and without hearing the central witnesses, testimony, cross-examination, the findings he made weren't open to him. I don't understand that as requiring identifying specific findings which were wrong. What that's saying is, well, because he impermissibly conducted a mini-trial with the consequences listed as to the inefficiency, the inappropriateness of the process, it resulted in findings which weren't open to him in a general sense. That's how I understand it. And I think you're being very critical of those specific grounds, but I'm not sure that's actually fair to the way it's put. And I'm not sure you can be quite so dismissive of the point, I think, as my Lord Justice Arnold was suggesting.
Well, let me have another go. I think it's fundamentally the same question, probably. Any objection that a judge has done something wrong has to identify what the thing was that's been done wrong and why it mattered in the result. If it didn't matter, then, well, it didn't matter. So the mini-trial objection, if it's to work, has to be that by impermissibly conducting a mini-trial, the judge found facts, and the judge shouldn't have found facts because there wasn't the evidence that there would be a trial. That's not the exercise at this stage. And it wasn't open to the judge to find facts. And he did find facts, and those made a difference in the result. And the problem of a mini-trial is to make findings before it's time to make findings. But if you can dispose of a case without having to make findings of fact on contested evidence, if you can do it on the defendant to the application's own evidence, for example, or their own pleading, and you don't have to make findings of fact, then the objection that there's been a mini-trial just it doesn't go anywhere, because it's just...
Could you explain to me why not? Because the complaint about a mini-trial is one of process. It's saying the wrong process was adopted. It's not about the end product, because you don't know what the end product would be of a correct process. And we have the authority of the House of Lords in Three Rivers to say that it's a wrong process to conduct a mini-trial. So the real question is, did the judge conduct a mini-trial or did he not? Because if he did, he was in error.
Well, my lord, I understand that, but I respectfully don't agree with it. If the judge... Firstly, the judge did not conduct a mini-trial. The judgment is very long and thorough and dense and detailed and engages with the documents and the allegations. But actually, on analysis, it is not a mini-trial. And if you read it carefully, you will agree with that, I hope. So there is not a mini-trial here. But I suppose the reason why I'm respectfully disagreeing is that if the judge did, he didn't, but let's assume that the judge did make a finding of fact, and that was an error and an error in the process, you don't overturn the judgment unless it's a fact that went somewhere in the analysis. If he's rejected a claim for 5 reasons, say, and the 5th reason was to do with the finding of fact, but there are 4 other ones that have nothing to do with findings of fact that also were sufficient to dispose of the claim, well, that's the end of the claim on a summary basis. The fact that the 5th one shouldn't have been made is neither here nor there. And it's only possible to describe what the judge has done as a sort of impermissible mini-trial by kind of not reading the back end closely enough, I'm afraid. And it's dense material. It probably takes a day and a half to read this and really crunch through it and see what's happened at the back end. And of course, it's tempting to say, well, front end, easy enough, that's all pre-settlement stuff, that's a short point of construction. Back end, very dense, but it doesn't follow that because it's very dense, he's done something wrong. You've actually got to read it and see if he did, and he hasn't actually. Can I just finish?
So are you saying in these circumstances and given the amount of material, it was inevitable that it was going to be long and dense, so that doesn't make it a mini-trial?
Well, I agree with most of that. I mean, a judge could have disposed of this claim in a much shorter judgment. There's no doubt about that. It's extremely thorough. It quotes 6 authorities at length where one would have done, for example, and it repeats that, so that actually, you know, it's great if you like to see all the authorities in one place, but it does lengthen the judgment. So it has the feel of a trial judgment. But actually, when you analyse it, it is not a mini-trial that's been done here, and the finding that the claims have been rejected for numerous independent reasons. And that's really what drives the length, that he's crunching through it point by point, and that's what's happened. It could have been shorter, but in fairness, that is not a terribly strong criticism of a judgment that otherwise doesn't contain errors. I want to finish, if I may, by saying that the criticisms that were made orally yesterday of the judge at 121, 151 and 152 are not in this appeal because they're not in the grounds. In relation to all the points raised in the grounds of appeal, the judge was right for the reasons that he gave. The judgment is excellent, and none of MRL's criticisms are valid, and those are my submissions.
Thank you.
Just come back one more go at this point. Looking at what the judge himself said at 173, he starts with the assertion, I have not conducted a mini-trial. But he then says the issues in this case, part of the case, turn in large measure of the plausibility of MRL's factual case. A critical appraisal of the evidence is required, lest which referred statements of case and the evidence considered for detail. And then, as my Lord Justice Arnold has said, he takes something in the region of 180 paragraphs to go through that process. In a situation where he hasn't had, there hasn't been disclosure, there hasn't been cross-examination, and one has to bear in mind, I think it was Justice Popplewell that he then was, who stressed that one always has to have in mind that things may develop. And I think the question is, isn't this an inherently impermissible exercise to embark upon this detailed a consideration of plausibility if it requires this much analysis to reach the conclusion that it's not plausible? Should that have been done?
Well, my Lord, I think you're asking a pretty similar question, and I may be giving a pretty similar answer, but just to pick up your specific points, at 173, he does say he hasn't conducted a mini-trial. He considers the authorities in relation to conducting into what the proper law, the proper exercise is at C, at some length, at section C of the judgment at some length. So he did have that well in mind. I haven't prepared submissions on it, but it's from page 192 and following. So he's considered it at least at some length, and it in fact is correct that a judge hearing a strikeout, hearing a Part 24 application is entitled to and should conduct a critical appraisal of the evidence. That is not the objectionable thing if you go through the authorities on summary judgment that he went through. And he has taken 180 paragraphs, and if you read those, when one reads them, one sees that they contain numerous independent reasons for why the post-settlement claims have been rejected, and those reasons do not depend on factual findings, far less impermissible factual findings. So that's really what I say about the objection on the grounds of a mini-trial. Just because it's long and just because he's been diligent, that doesn't make it a mini-trial.
Well, if he had on each of the sales, as it were, a knockout point which didn't require factual findings, then obviously that's an answer to the mini-trial point. But the question is, why didn't he just deal with it on that basis?
Well, you'd have to ask him, my lord.
Can you identify for me on each of the 3 sales, what do you say are the knockout points he could have dealt with it?
Could I just ask a quick question before Mr. Glasgow gets into the detail? Because I'd also like to refer to what the judge says at page 278 in the file. It's his heading to paragraphs 180 and following. And the heading is "The Facts and Evidence." It looks suspiciously like he's making findings of fact, doesn't it? The judge seems to have been beguiled by this expression, critical examination. And I think one's got to be very careful with that expression, because it's not the function of the court at this stage to be interrogating the written evidence, is it?
Well, my lord, you are entitled to look at MRL's evidence, and that's really what this section is doing. We've got division of labour between the respondents, and I should probably leave the detail of sales 1 to 3 and this part of the case to Mr. Colton, because it's something he's focused on. And what he's doing in this section, just briefly in relation to my Lord Justice Phillips' point, paragraphs 180 and following, he's getting into the facts and evidence as alleged by MRL. That is a permissible exercise. The knockout blows, when they come thick and fast from 302 and following. And there are plenty of knockout blows. And maybe, I mean, a useful exercise, it's one that I found helpful, is to actually read from para 302, page 325 of the judgment to the end. And that shows you the knockout blows, and then go back and see if anything impermissible has been done that affects that in 280 to 301.
But for example, Mr. Gletto, what do you say of paragraph 306, which we were taken to by Mr. Fenwick? Do you think that's, or would you say that that is a permissible testing of MRL's evidence, or is it deciding on the documentation before him, a point which actually needed to be dealt with after cross-examination and disclosure?
My lady, I'm afraid I'm not going to say anything about this because it's Mr. Colton's territory, not mine. So he's heard your question. There are numerous independent reasons why these post-settlement claims were rejected.
Thank you, Mr. Gledhill. It's something comes back to bite one, doesn't it? When I said no repetition or overlap between the respondents. Thank you. Any other questions? Lord Justice Arnold, any other questions?
No, thank you.
Thank you very much, Mr. Gledhill. And thank you for finishing well within time. I think now we move on to Mr. Collins, the fifth respondent.
Thank you, my lady. Given the debate that's just been taking place, I should probably start with mini trials so far as my client is concerned. Yesterday, because what Mr. Fenwick seeks to do is to accuse everybody of involvement in a mini trial. And indeed, yesterday, what Mr. Fenwick said was, in fairness to the judge, he was encouraged endlessly by the defendants for days and days that he should do this, that he should look at the facts and reach conclusions on every single fact available. Well, he wasn't encouraged by me, because our situation in this case is very different, and we're only involved in the first half of the case and not the second half of the case. Our application for strikeout and summary judgment was first in time by quite some months before everyone else piled in behind us. And we made an application for summary judgment in relation to the settlement agreement. And it had to be summary judgment because, but for the settlement agreement, there is an arguable case to go forward in relation to the first half, namely the unlawful means conspiracy, and we don't seek to go behind that. My only point is that his lordship was correct in relation to the settlement agreement having compromised everything up to the point of the settlement agreement, and I gratefully adopt my friend Mr. Gledhill's submissions in relation to that. We then had a strikeout application as well, which was a proper old-fashioned strikeout application with no evidence, because it looked solely at the pleading. Because not only is there a claim against Mr. Brooks for the unlawful means conspiracy, there were also a number of individual causes of action pleaded against him. For example, breach of fiduciary duty and misrepresentation. And we took issue with those on the basis of the pleading only, without any surrounding evidence at all. And we needn't get involved in any of those, because his lordship did strike out all of the individual claims against Mr. Brooks, and they're not sought to be resurrected on this appeal. The only claims beyond the unlawful means conspiracy, and that all depends upon the settlement, which are sought to be resurrected, are individual claims against Bonhams based upon breach of fiduciary duty by them alone, and it doesn't include me, or for that matter Mr. McLean, but Mr. Weeks can speak for himself. And the post-settlement matters, which were just being debated a few moments ago. Now, my lady, yesterday, your ladyship and my learned friend was dealing with the first half of the case at this point, when he was, because his complaint about the trial has broadened out to the first half as well as the second half, and that's why I've been sucked into it as being, we're all in the same boat. But in my submission, that's not fair or right. But your ladyship, in trying to summarise what my learned friend Mr. Fenwick was saying, was that was really on the mini trial point as made yesterday, before we got much more into the mini trial on the second half of the claim, was that the points Mr. Fenwick was making go to mini trial. Well, they don't in my submission, insofar as the first half of the claim is concerned. Certainly, the grounds of appeal mini trial point are completely limited. Ground 6 is completely limited to the second half of the claim. And it was also said that Mr. Fenwick's submission amounted effectively to infecting the settlement, the judge's findings on the settlement agreement. Because if he'd made certain findings in relation to the pre-settlement point, that might infect his approach to the settlement agreement and so on. But in my submission, that's not right either. Because when it came to the settlement agreement, as Mr. Gledhill has taken us through, his lordship did look at the entire context in an orthodox way, applied the authorities, and came to a conclusion on the settlement agreement. And insofar as the learned judge dealt with the individual claims against, for example, my client, and indeed against the others, which he was invited to do by us, he can hardly be faulted for having struck them out, because they're not sought to be resurrected, certainly not so far as my client is concerned. So, to make this point finally good, my learned friend Mr. Fenwick was rather going also against a previous acceptance of this procedure. And I would just ask you to turn up supplemental bundle at tab 19, please, page 163. Because this was the evidence in answer on my strikeout and summary judgment application from Miss Gray of Mishcons, instructed by MRL, which is, as you can see, only 5 pages in length. And my evidence in support was really had no evidence in it at all. It it exhibited the relevant documentation but did not travel outside of the pleading or the documents referred to in the pleading, it sought also to make the points that we were making, so that nobody was taken by surprise in this context. So at the top of page 164, Miss Gray summarises our points quite correctly. The claim now being made is settled by the settlement agreement, and the claim as pleaded doesn't disclose a cause of action, alternatively one with reasonable prospects of success, and that's a sort of catch-all for all the individual claims. The application, that's my application, predominantly raises matters of law and not fact. Then Miss Gray turns to the background of the matter, and she says it's set out in full in the particulars of claim, which I did not travel outside of, and certainly not outside the documents referred to therein. And then she does, in fact, set out a little bit of the background in her evidence. But then, if we look at paragraph 19 on page 165, 4 lines in, whilst many of the allegations of conspiracy against Mr. Brooks relate to the period before the settlement agreement, there are allegations which relate to his acts after the settlement agreement, and she cites certain paragraphs, but I'll come back to that because it is not right that we have any involvement whatsoever in the period after the settlement agreement, and certainly no claims are made against us in relation to it. So in this part of the application, Mr. Brooks therefore seeks to strike out some but not all of the claims in conspiracy, and alleges that the claim against him, which predates the settlement agreement, in particular unlawful means conspiracy, compromised. This turns on a short point of construction. Does the definition of claims in the settlement agreement include claims of deliberate wrongdoing and dishonesty? MRL's case is clear. The clear words are required to exclude liability for deliberate wrongdoing and dishonesty. No such words exist here, or they've all been compromised, except claims of fraud and dishonesty. And then at paragraph 22, she asserts in the second sentence, an unlawful means conspiracy is a claim of dishonesty, as it requires proof that Mr. Brooks knew that he was acting unlawfully, and that, of course, is incorrect on the racing partnership case, although I note that that's coming before the Supreme Court for 2 days next week, tantalisingly. Paragraph 23 is then dealing with the heading conspiracy and freestanding claims, and in paragraph 23 there's a reference to fiduciary duties, and paragraph 24 to fiduciary duties of good faith and misrepresentation. And so it was entirely accepted that the point about the settlement agreement was one which was fit for summary determination, as indeed it was, one way or the other. So there's no question, so far as Mr. Brooks is concerned, of mini trial. Now, looking at the grounds of appeal again, which we were just in with Mr. Gledhill, I can probably I'll take them backwards because it's only the first ground of appeal that concerns me. So ground 6 is an impermissible approach for strikeout or summary judgment by conducting in effect a mini trial. In consequence, the judge erred 1, 2, 3, 4, and they all relate to post-settlement. 1 is specifically post-settlement, 2 is claims against Lohomij, 3 again is claims against Lohomij, and 4 is dismissing the amendment application, but that doesn't add anything because we all agreed that we proceeded on the basis of the draft amended particulars of claim. Grounds 3 and 4, or rather 2 and 3, are only in relation to specific claims against Bonhams and not anybody else, save in ground 3, sub 3, it's against Lohomij and Mr. Laumann, but that is based upon a dishonest assistance claim, which of course requires a fiduciary duty and breach of it on the part of Bonhams. So we're not involved in 2 and 3. We're not involved in 5, which is against Bonhams and Butterfields. 4 is just a catch-all in relation to conspiracy. And so Mr. Brooks is only concerned in ground 1, which is settlement. And Yesterday, my learned friend Mr. Gledhill took us to paragraph 121 of the judgment, which is core 11, page 252. And I'd ask you just briefly to look at that again, because what Mr. Gledhill submitted in my submission correctly was that there was no challenge to this, and therefore there could be no, it was not open to my learned friend Mr. Fenwick to talk about any post-settlement conspiracy, because there was only one conspiracy, which was pre-settlement. And in my submission, that is right, so far as the allegations are concerned. And indeed, this appears to be accepted in a number of places by the claimant. So, for example, if we turn on to Core tab 13, this is a document headed Grounds of Appeal, which was submitted to this was submitted to His Lordship below in support of the application for permission to appeal, which he did not grant. And if we look at page 352, we can, in fact, paragraph 9 starts on page 35 to the bottom of 351, but it's subparagraph 3 which is particularly important in my submission. The claimant does not assert, and this of course is the claimant's document seeking permission to appeal, and rather full, it's headed Grounds of Appeal, they're rather full, but it's more like a skeleton argument. The claimant doesn't assert a new conspiracy following the settlement agreement, as opposed to further unlawful acts pursuant to the original conspiracy, because one, the claimant's case is that the relevant defendants are precluded from relying on the settlement agreement in any event, and two, the claimant is unaware prior to disclosure of any further acts of combination post-dating the settlement agreement. And paragraph 78 of my learned friend's skeleton argument, which I think he took us to yesterday, which is in core at the end of tab 1 at page 56. Really encapsulates the position in that the real vice of which complaint is made is all about the first stage. It is all about the auction in Carmel in California at Quail Lodge, and the fact that this was all done in order to augment the value of bonds for the purposes of those interested in the equity in bonds and sale of it, which has in fact taken place, which included Lohomij and Mr. Lambert, and that's how the whole thing came about. The thesis set out in the letter before action, which was then set out in the executive summary at the beginning of the amended particulars of claim. And so we say, and yesterday I think my learned friend said that the conspiracy began before and continued after the settlement, and in fact the executive summary is to exactly the same effect. I would, if I may, just like to cement this point by reference to the amended particulars of claim, because it's so important for the late Mr. Brooks and his family and estate. The amended particulars start at 368. And in fact, paragraph 5 of the executive summary on page 369 refers to the unlawful means conspiracy continuing after the auction and after the date of the settlement, as Lohomij deliberately interfered and unreasonably refused to consent in sales and so on, and then there's a reference to Mr. Knight as well. But the paragraphs which are post-settlement paragraphs, which were highlighted by Miss Gray, and indeed I'll highlight some myself which weren't highlighted by her. The first is at page 391. And Miss Gray highlights paragraph 96, which is said to be a message, a forthright message from Mr. Brooks via his lawyer, Mr. Davis. But one can see from paragraph 97 correctly saying, as a result of Lohomij's refusal, sale 2 collapsed. So however Mr. Brooks is alleged to have expressed himself forthrightly, it was neither here nor there. In fact, at this point, Mr. Brooks had taken a back seat from the business because he'd suffered a serious heart attack with serious ramifications in August 2016. So that's paragraph 96 on the part of Miss Gray. Her next reference is paragraph 117, but before then, on pages 393 and 394, there's another reference to Mr. Davis in paragraph 103, and of course we know from paragraph 96 that it's pleaded that he is Mr. Brooks' lawyer. At a meeting in 2017 at which Mr. Knight, Mr. Coppell and Mr. Davis were present, Mr. Lohomij informed MRL that Lohomij refused to consent. Again, nothing to do with Mr. Brooks. And there is that reference to Mr. Coppell is perhaps not unimportant, because at paragraph 106 it is said that there's no allegation of wrongfulness against Mr. Coppell, but he was at all times acting on the instructions of Bonhams, Mr. Brooks, Mr. McLean, Lohomij, and or Mr. Lohomij. So he seems to have worn a number of hats. But every time that Mr. Coppell is referred to in relation to the post-settlement period, none of them relate to Mr. Brooks. So, for example, at paragraph 105, furthermore, Mr. Coppell, Lohomij's lawyer, on the instructions of Lohomij and or Mr. Lohomij, interfered. And the same goes for references at paragraphs 36 and indeed 113 on the next page, page 395, Mr. Coppell, Mr. Lohomij's lawyer. Now, the next paragraph highlighted by Miss Gray is paragraph 117, subparagraph 3. And paragraph 117 starts on page 395. The claimant's primary case is that from at least May 2014, the defendants, and each of them, were involved in the unlawful means conspiracy. And 1173 says, following MRL's letter before action, there was an alleged threats by Mr. Brooks, again in forthright terms. But again, the reference that the date that is there given of the 13th of April 2015, of course, predates the settlement agreement by quite some months, and we've already seen that an allegation of Mr. Brooks allegedly being forthright after the settlement agreement really was neither here nor there, because it had no effect on anything, because it was all at that stage to do with Lohomij or Mr. Lohomij. Then Miss Gray goes on to paragraph 121, which is referred to in its entirety. And these are the alleged unlawful acts pursuant to and in furtherance of the conspiracy. And they are 9 in number with the amendment at 4A. But it's only 1 to 4A, which are, well, 1 to 4A are all prior to the settlement agreement, and they do involve Mr. Brooks, obviously, the auction and so on and so forth, and the individual claims against him. For example, in 3, misrepresentation, 4, breach of fiduciary duty and or lack of care, all of which were individually struck out and not sought to be resurrected. Now, the alleged unlawful acts at sub 5 to 8 are all post the settlement agreement, because the settlement agreement it's interesting. It's not only comprehensive in its terms, as Mr. Gledhill submitted, but it also is intended to draw a line partway through this commercial relationship and set a new foundation for the commercial relationship going forward, upon which completely different claims are then made in relation to the sale of the cars and impeding consent and so on and so forth, in relation to none of which was Mr. Brooks involved. So 5, 6, 7 and 8, breach of the settlement agreement by Bonhams and Lohomij, breach of a facility agreement by Lohomij, procurement by Mr. Knight or Mr. Lauman, and then a reference to this motor car, which is the only matter that's going on to trial, which now resides in Mr. Lauman's Motor Museum in The Hague. So that's paragraph 121, and then lastly is paragraph 135 highlighted by Miss Gray, and that can't have anything to do with Mr. Brooks because it starts Bonhams and or Mr. Knight are liable in economic tort for procuring Lohomij's breach of the amended facility agreement, and so there's simply no reference to Mr. Brooks there at all. So that is why we respect that. That's the basis upon which we brought our application for summary judgment and strikeout. The only relevant matters against Mr. Brooks were pre-settlement, and they were all settled. And there were no arguable relevant matters post-settlement on the face of the pleading. Without any analysis of vast amounts of evidence, of which there was only a tiny amount on my application.
I'm not quite sure at the moment if you're saying there is no claim against Mr. Brooks, or there was a claim but you struck it out because it wasn't well founded.
Well, the claim against Mr. Brooks, yes, I mean there was a lack of clarity in these particulars. I would accept. There was obviously a claim against Mr. Brooks in relation to unlawful means conspiracy. And what we were concerned to do was to demonstrate that had been comprehensively settled and compromised by the settlement agreement. And then what we sought to do were 2 other things. Firstly, to take issue with the individual claims against Mr. Brooks, of which there was misrep and breach of fiduciary duty and so on, all of which the learned judge struck out on the basis that they were simply improperly, inadequately pleaded. And secondly, to demonstrate that this really is a case of 2 halves, and that we had no involvement whatsoever in the second half, so that any claims that arise in relation to the second half could have no impact on Mr. Brooks at all, even if they were being made, so that there could be no new conspiracy which hadn't been settled by the settlement agreement which settled the principal claim, which was the auction conspiracy, the alleged auction conspiracy. And indeed, there were no other freestanding causes of action whatsoever after the settlement agreement, because we simply weren't involved in any of it at all. I mean, we just simply don't feature.
Is there any issue over this? I'm not slightly at a loss at the moment as to whether or not we're addressing an issue, or whether you're just explaining something which isn't an issue.
All that we therefore say is that so far as Mr. Brooks is concerned, it's the settlement agreement, and that's the only issue that affects him on this appeal. So perhaps I was labouring that point a little bit too much, and I'll move on.
So you say it's ground 1?
It is. It's only ground 1, and it's ground 1 in relation to. It's only ground 1, and ground 1 is only a conspiracy prior to the settlement agreement. So, and that's important. There's no, it's accepted that there's no fresh conspiracy thereafter. Certainly nothing that can involve Mr. Brooks, because he just doesn't feature at all in the factual analysis or anything after the settlement agreement.
Well, it's ground one because you're alleged to be party to the conspiracy, but because you're alleged to be party to the conspiracy, you do also have an interest in the alleged unlawful acts which are necessary to found that conspiracy. But if you say you don't pursue any arguments in that or rely upon the other parties, then that's fine.
Well, certainly I went to paragraph 170 of the learned judge's judgment, and that is that if the settlement agreement is not as comprehensive as we say and is as Mr. Fenwick says, then I accept that there's a claim against Mr. Brooks. I'm not seeking to deny that. Paragraph 169 provides that there's no separate unlawful act after the settlement agreement, and even if there's some argument that that after the settlement agreement there might be my learned friends might be in some difficulty on a mini trial point, it has nothing to do with me, because I just simply don't feature in any of that. That's really what it boils down to. And so there's no mini trial so far as I'm concerned, because everybody was ad idem that the settlement agreement point and the unlawful means conspiracy point is all pre-settlement and perfectly capable of being dealt with on a summary basis.
Thank you, Mr. Collins. Unless you want to ask anything else, we've overrun for the purposes of a break for the transcript writers, and I propose to rise now until 12:10.
Thank you very much, Milady.
All right.
There is a claim against your client and against one client. There's a conspiracy claim against all the defendants. The one where you go, well, that's subparagraph 121, subparagraphs 1 to 8, it's against all of them. So I think you just need to say if you're wrong. But he's in the same place.
He is in the second.
Yes. I'll do that. Okay. Fine. Yeah. Sure. Yeah. I will. Yeah. 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 No, of course, but the problem is we can, in theory, still be stuck in the trial. Yeah. Yeah. If 6 is resurrected, then we're stuck in this trial that absolutely has nothing to do with us at all. Yeah. But it only happens if we, I mean, it's all theoretical, it only happens if we lose on if we lose on round 1. It's only because we're only tagged on conspiracy, so we have to lose on round 1. We lose on round 1, and so in other words, if they win on rounds 1 and 6, we're back in. No, there's no unlawful act against any of us in respect of post-settlement agreement, except for conspiracy. So that's the only thing wrong because of the claims against Bonhams and Lohomij. I'll come back on that because I've got a response next on it. So, yes. I've got a response. I'll take it to court. Yeah. I'll come to the which is what
although we are the ones who are paying for conspiracy. It's such a strange, you think the most important thing that justice is being done for the parties. Just, or you're used to it.
was to get permission to release the will. Yes. Not for that point.
You shouldn't feel the need to.
Is this the original?
So those problems they make. It's unnecessary. Whatever difference.
All right. Mr. Cox, where were we?
Well, I'd really said all that I wanted to say in relation to the procedure and the grounds of appeal and settlement and the two halves of the case. And I was only just going to deal very briefly, it only take 5-10 minutes or so, with the discrete point that we seek to raise by the respondent's notice insofar as necessary. It's the point that was raised yesterday when my learned friend said on page 48 of the transcript, the judge should have been led to conclude that there must be something either in the express wording of the settlement agreement or in the surrounding circumstances known to both parties, which meant that the court can reasonably infer that claims in fraud and conspiracy were envisaged and intended to be covered before the exclusion would extend to it. And then my Lord Justice Phillips interposed at that point. You mentioned the word conspiracy there. Do any of the authorities, when discussing fraud, extend it to conspiracy as well? And my learned friend responded, I don't think so in terms. And of course, what they all deal with fraud and deliberate wrongdoing. Conspiracy here, which involves a deliberate intention to injure, is in my submission in the same category as that. Well, we saw from Miss Gray's witness statement that she asserted that claims in fraud and dishonesty were excluded. And that's also what is pleaded in the amended particulars of claim at paragraph 138 of the amended particulars, which is on page 406 of tab 16 of the core bundle, where it is said that MRL's primary cases that the settlement agreement did not compromise any claims in fraud or dishonesty. But paragraph 66 of the amended particulars of claim do take it further, because they slip the word conspiracy in as well. For the avoidance of doubt, the settlement agreement...
that's where?
That's on page 385, my lady, paragraph 66. So paragraph 138 is on page 406, and paragraph 66 is on page 385.
Thank you.
For the avoidance of doubt, the settlement agreement did not settle any claims in dishonesty, fraud, and or conspiracy, which MRL had against the parties. Well, of course, conspiracy is a tort, and claims in tort were specifically mentioned in the definition of claims in the settlement agreement. And if one looks at paragraph 129 of the amended particulars of claim, which is on page 403, what is said there in paragraph 1291, further alternatively, the facts and matters particularised above amount to a breach of Bonham's contractual duty under the commercial agreement to act with reasonable skill and care honestly and or in good faith. Of course, this is, then what is said in paragraph 131, for the avoidance of doubt, MRL relies on the facts pleaded in paragraphs 129 and 130 as unlawful acts in support of the unlawful means conspiracy, but not as freestanding causes of action, as any such cause of action would have been settled under the terms of the settlement agreement. So it seems to be accepted that a breach of contract, which is a breach because of a failure to act honestly, i.e. they've been acting dishonestly, is something which is settled. And as Milena friend Mr. Gledhill might disarmingly put it, to introduce pretty bad stuff into a breach of contract or a tortious claim doesn't make it any less a contractual or a tortious claim. And the same goes in relation to conspiracy. As was observed yesterday, dishonesty is not a necessary part of an unlawful means conspiracy. That was accepted by Milena friend at page 56. I agree that an unlawful conspiracy, in response to my Lord Justice Phillips, I agree that an unlawful conspiracy doesn't have to include dishonesty, but in this case, we've made it pretty clear that it was dishonesty from the start. So none of this elevates it from being a tort which is caught by the settlement agreement in our submission, and there is an inconsistency where they think that a contractual claim involving dishonesty is settled, whereas a tortious claim, conspiracy involving dishonesty, is not. And the last point is that if one analyses it, one analyses it in the way of there being an exclusion for fraud or dishonesty, which is the way that it's been put, without adding conspiracy into it. The only way in our submission of making sense of that is, again, not to just say that it was an egregious conspiracy or an egregious breach of contract or an egregious tortious claim. It is that fraud has to be a necessary part of the claim, and this is what is covered by His Lordship at paragraph 118 of the judgment, at page 249, tab 11 of the court. And where he dealt with my submissions on this below, by reference to the interactive e-solutions case, at the end of which Lord Justice Lewison, with the agreement of the remainder of the tribunal, said, in the context of legal liability for claimed loss, it seems to me that the only workable criterion is whether an allegation of fraud is a necessary ingredient of the legal basis on which loss is claimed. In other words, whether an allegation of fraud is a necessary averment to support a cause of action, which it plainly is not in relation to conspiracy. So if the way that Milena friend puts it is that there is some exclusion to the settlement agreement for fraud or dishonesty, then the only claim which he now brings against me, which is for an unlawful, or seeks to bring against me is an unlawful means conspiracy. Fraud or a dishonesty is not a necessary averment to support such cause of action. And the fact that you might say that it's all done in egregious circumstances does not work juridically. But in fact, what His Lordship then did was he preferred not to go down this particular rabbit hole which I had submitted to him, and he went back at the end of paragraph 118 to the matter of construction, and he went back to the terms of the agreement, which of course includes claims in contract and tort, of which conspiracy is one, and then construed the settlement agreement in an orthodox way by reference to the relevant materials, which were in fact referred to in the particulars of claim, and in particular the letter before action. So those are our submissions for the Fifth Defendant.
And is this linked to the line of authorities which I think is best known as Beeman and ARTS on whether a cause of action is based on fraud purposes of exclusion to limitation?
Possibly, if I was more fully aware of that line of authority, and in particular, that case. But I don't know whether that's something which is referred to in the interactive case. But the interactive case we've got in volume 1 of the authorities. It's quite short. It was in fact in relation to an exclusion clause, but it's of more general application. It's tab 11. I think it's more, the authorities referred to more are those which deal with the commercial impact of excluding liability for fraud and whether it's part of the whether it can be said to be part of the bargain or something of that sort. But his lordship's conclusion, which was cited in the judgment, is at paragraph 25. And there's also a passage at paragraph 23. Liability arising from fraud must mean liability in relation to a fraud which is a necessary averment. Otherwise, the liability wouldn't arise from fraud; it would arise from something else. And of course, what the definition of claims in settlement agreement says is claims in tort or conspiracy, which is an allegation of liability for claims in contract or tort, which is of course a claim for liability in contract or tort. And what we say about that is that if you have a tort, the fact that it might, or a breach of contract, the fact that it might involve egregious circumstances is neither here nor there, because such egregious circumstances are not a relevant part of such a claim for contract or tort. It's just part of the background circumstances.
Well, I think that is the Beeman point, which in that case, I think it was said, what was being relied upon was what was said to be a fraudulent conversion.
Yes.
And what the court said is, well, it may have been fraudulent, but it's not. The cause of action is not based on fraud. The cause of action is simply conversion.
Yes, my lord. That with respect is exactly the same point. That's exactly the same point. Whether it's a conversion by accident or a particularly egregious conversion, it's still a conversion, which was.
But how far such technical points really help us on the construction of a particular?
That's why I think his
agreement.
lordship it was kind enough to engage with me in this debate, which was, I have to confess, solely mine below, because I think solely mine here, and then said, well, that's all very well, but let's get back to the terms of the settlement agreement. However, in my defence, all I'm doing is I am addressing one part of my learned friend's claim, where he says that there's an exclusion from this settlement for claims in fraud or dishonesty. And if he's right, conspiracy is not such a claim, so it doesn't even work on that part of the argument. But in fact, I would respectfully agree that the better approach is that of the learned judge, which you just approached this as a matter of construction. And conspiracy is a tortious claim, and that's specifically included quite apart from the surrounding circumstances. Thank you very much.
Thank you. I think that means that we move on to Mr. Weeks.
Thank you, my lady, my lords. On ground one, we gratefully adopt what my learned friend Mr. Gledhill said, and we have nothing to add in that regard. The judge was right for the reasons he gave, as exemplified by Mr. Gledhill's submissions. On the mini trial point, which Mr. Collins has recently addressed the court on, that is the proposition that MRL's complaint that there was a mini trial applies only to ground 6 and only to the post-settlement agreement cause of action or causes of action. We adopt what Mr. Collins said, and we don't need to supplement that either. My lady, my lords, I intend to address 3 areas in my submissions. The first is, without, I hope, duplicating and only, I hope, helpfully supplementing what Mr. Gledhill has had to say, I do wish to look in particular at some of the authority on fiduciary duty and also on the duty of good faith. I also wish to address ground 6, which will, I hope, add to what Mr. Collins has addressed you in that regard, because Mr. Collins' client and mine are in the similar position, which is that we face what is, we would submit and submitted below, a really rather extraordinary conspiracy claim applying to us after the settlement agreement, in circumstances where in the period after the settlement agreement we are simply not alleged to have done anything wrong. So we have put in a respondent's notice which addresses this point amongst others, to say that if it were the ultimate conclusion of this court that there should be any further proceedings in relation to the post-settlement agreement causes of action, they cannot apply to my client, Mr. McLean, and by the same token I would suggest cannot apply to Mr. Brooks, and we'll come to why we say that, if I may, in due course. As regards fiduciary duty, ground number 2, the judge held that a fiduciary duty cannot be owed by one party to another when they're involved in a commercial negotiation. When a party is negotiating a commercial contract, it is necessarily acting in its own commercial interest, so it cannot at one and the same time be subordinating its interests to those of the counterparty. Now, yesterday, Mr. Fenwick argued that there might be an alternative basis, nevertheless, for imposing a fiduciary duty. And this is that he said his clients expected Bonhams to be acting in MRL's interests. He said during that period of time, whilst they were considering and preparing the cars, it was getting ready for them to acquire. My clients were expecting Bonhams to be acting in its interests in deciding how to deal with it. They wouldn't have been buying and dealing with them unless that had been agreed. There are several authorities which bear on this question of expectation, and one which we would respectfully suggest is particularly instructive, and it is one which the judge referred to, and Mr. Fenwick and indeed Mr. Gledhill have referred to in parts as well from that part of the judgment, and that's the judgment of Lord Justice Leggett, as he then was. It is a first instance decision in the case of Al Nehayan and Kent. And if I may ask the court please to turn that up. That's at Authorities Bundle, and conveniently enough, it's Authorities Bundle Volume 1, Tab 1. Now, this was a case in which there was an oral joint venture relating to the acquisition and operation of hotels. And part of the joint venture business was later demerged under a rudimentary framework agreement with rather limited express terms. And the relationship was based on a strong personal friendship between the two parties who were both individuals. And Mr. Fenwick yesterday read part of the judge's judgment. That was paragraph 138 of the judgment below in our case, in which the judge quoted from this decision. And if we might pick that up, please, first, which is it's at paragraph 159, which is page 267 of the report. Paragraph 159 is the one that Mr. Fenwick read yesterday, and I therefore do not need to read it out again. But what we do place particular emphasis on is these propositions, which we do not understand to be capable of any serious dispute, are simply incompatible with a commercial contractual negotiation. So just below C, Lord Justice Leggett says the essential idea is that a person in such a position, it's a fiduciary position, is not permitted to use their position for their own private advantage, but is required to act unselfishly in what they perceive to be the best interests of the principal. And that's said to be the core obligation of loyalty from the Mothview case. And the Lord Justice Leggett goes on to say, loyalty in this context means being guided solely by the interests of the principal and not by any consideration of the fiduciary's own interests. And so what we say there is that is quite impossible to envisage, at least in any ordinary contractual or commercial contractual relationship. If we might now move to paragraph 163 on page 268, and this is where the learned judge begins to address the issue of trust and confidence. And he says the counsel for Mr. Kent placed heavy emphasis on the close personal relationship between Mr. Kent and Sheikh Tanu, and on the evidence for the most of the period, at least their business association, they reposed a high degree of trust and confidence in each other. But the existence of trust and confidence is not sufficient by itself to give rise to fiduciary obligations. In the first place, the question whether one party did in fact subjectively place trust in the other is not the test. And we emphasise that because of my learned friend Mr. Fenwick's submissions were concerned with what he asserted to be the subjective beliefs and views of his client. And that's simply not irrelevant consideration. And as often in this context, Lord Justice Leggett then refers to the judgment of Mr. Justice Dawson in the hospital products case. It says a fiduciary relationship does not arise where, because one of the parties to a relationship has wrongly assessed the trustworthiness of another. He has reposed confidence in him, which he would not have done had he known the true intentions of that other. In ordinary business affairs, persons who have dealings with one another frequently have confidence in each other, and sometimes that confidence is misplaced. That does not make the relationship a fiduciary one. A fiduciary relationship exists when one party is in a position of reliance upon the other because of the nature of the relationship and not because of a wrong assessment of character or reliability. And what we place particular reliance on here is that the test is concerned with identification of whether there is a fiduciary relationship, not a subjective view as to trust and confidence. And once one is looking at the fiduciary relationship, the existence or not, one has to consider the nature of that relationship. And here, an argument as to the fiduciary relationship doesn't get off the ground. We are concerned with a commercial contractual negotiation beginning on or around the 22nd of May 2014. It is an arm's length relationship in which MRL is represented by an external lawyer, Mr. Walmsley of Spring Law. The negotiation, such as it is being conducted by my client, Mr. McLean, a non-executive director of Bonhams, and what they are concerned with is terms of exclusivity and then negotiating a potential commercial transaction. That is a world away from any situation in which one would say that the nature of the relationship is one in which there is, as Lord Justice Leggett summarises, a relationship in which one party is entitled to repose trust and confidence in the other. The learned judge goes on in paragraph 164 further to explore this issue of the nature of trust and confidence, which is a feature of the fiduciary relationship, and then says there plainly are many situations in which a party to a commercial transaction may legitimately repose trust and confidence in another without the party owing any fiduciary duties, and refers to the decision in the House of Lords re Goldcorp. Over the page, quoting from Lord Mustill, quite a familiar dictum ending by saying it is possible without misuse of language to say that the customers put faith in the company and that their trust has not been repaid, but the vocabulary is misleading. High expectations do not necessarily lead to equitable remedies. And this might be familiar, because in this case, of course, the ultimate peak of Mr. Fenwick's complaint is to say that there was a change of position at the last minute. In the commercial negotiations, he alleges that there was a change of position from a sale to a loan. Now, my clients don't accept that. The judge doesn't accept that. And we say it's clear from the 22nd of May email in any event that what was being considered was, in fact, a loan. But that doesn't matter for present purposes, because for present purposes, the question is, does such a change of position give rise to a fiduciary relationship, or does it allow an allegation of breach of fiduciary duty? And we say, no, it doesn't, because one starts from the email on the 22nd of May and says, if at that time there were high expectations on the part of MRL as to making a transaction for the sale or the auction of these vehicles, is that something which is protected by the law of equity? We say no, because they're ordinary commercial contracting parties who are entitled to conduct their negotiations in their own best interests.
Forgive me there, it seems slightly allied the questions of whether or not a fiduciary duty was owed, or came to be owed, and whether or not a fiduciary duty was breached.
Yes.
But it seems to me that we're only talking here, aren't we, about whether there was a fiduciary duty?
Yes, yes.
Nobody's suggesting that if there was a fiduciary duty, that there might not have been a breach here.
Yes, and I'm grateful to my lord, that's quite right. I think the way I should have put it is this. The expectation which MRL is relying upon or alleging, they say that they expected that they expected that Bonhams would enter into a transaction on particular terms. And they say it is that expectation that they had on the 22nd of May 2014 which gives rise to a fiduciary duty. And we say that can't be the case because high expectations do not lead to equitable remedies. There has to be something in the nature of the relationship between the two parties which gives rise to a fiduciary relationship, and not whatever the subjective belief of MRL might have been as of the 22nd.
I don't think that's even alleged, is it? I think the full extent of the case against you is that there was the exclusivity agreement, and that, it seems, by its nature and or by operation of law, gives rise to a fiduciary duty.
Indeed,
that's all that's said.
Indeed, my lord.
And there's no pleading that there was an expectation other than derived from that agreement.
Indeed, my lord. And I absolutely endorse what Mr. Gatel said in that regard. And I don't shy away from the pleading point, which is to say, the only allegation which has been pleaded, the only allegation which the learned judge had to consider below, and it's jolly unfair, in fact, to be challenging the learned judge's judgment on the basis that wasn't pleaded. But those were the submissions which were made, as I understood it, by my learned friend yesterday, saying that the court should take account of what he asserted to be the subjective beliefs and expectations of his client. We say that it's not, in fact, necessary to get there, because it doesn't get out of first base, because it's not a pleaded allegation. But if I'm wrong about that, and the court were prepared to consider this expectation argument, we say in any event that it's wrong. And if I may simply complete what the analysis of the expectation issue is in Lord Justice Legate's judgment, and I was cautious about doing that, because the one thing everybody knows about fiduciary duties is that nobody ever wants to commit to proposing a test. Like an elephant, one knows a fiduciary duty when one sees one, but can't describe what it actually looks like. But in paragraph 166, the learned judge says, for the reasons given, the nature of the relationship between Mr. Kent and Sheikh Tanoon in the present case did not give rise to any legitimate expectation on the part of Mr. Kent that Sheikh Tanoon would put aside his own self-interest and consider only what was in the best interests of the companies or of Mr. Kent in making decisions about whether to increase or liquidate his investment. And we say, if one looks at that test, this is quite a preposterous case. It would be preposterous to suggest that on the basis of the exchange of 2 emails on the 22nd of May 2014, that MRL had any expectation, let alone a legitimate expectation, that Bonhams would be putting aside its own self-interest and considering only what was in the best interest of MRL when negotiating the commercial agreement. That wouldn't even be a negotiation properly so-called. It would be a rolling over. We say, in those circumstances, it is impossible to envisage that in the ordinary case of commercial contracting parties, that there can be a fiduciary duty owed when they're negotiating a contract. Now, my lady, my lords, I should show you one further authority in this regard for completeness, because it does appear that there has been recognition in 2 cases that a fiduciary duty can be owed between commercial contracting parties negotiating a contract. And that is in a case that's recognised by Mr. Justice Nugee, as he then was, in a case called Glenn and Watson, which is at tab 9 in this bundle. And I take the court to it to demonstrate that it's perhaps at least not an impossibility that such a fiduciary duty could be owed, but certainly there's no suggestion that it could be owed in negotiation between 2 commercial contracting parties at arm's length. In this decision, if I may go first to, so it's in paragraph 131, subparagraph 8. Unfortunately, it's not the decision. The pages of the decision are not numbered, but it's in the pages which the page on the left has got a number 6, and then there's 7, 8, and 9 on the page on the right. It's actually page 7 if they've been numbered. In subparagraph 8 on this page, the judge, having summarised various well-known authorities, concludes that this analysis also explains why fiduciary duties will not readily be found in commercial settings. In commercial dealings, the relationships are usually primarily contractual, and it is of the essence of commercial contracts that each party is usually entitled, subject to the express and implied constraints of the contract, to seek to prefer its own interests, and is not obliged to put the interests of the other parties first. And so the judge is there stating what is a general and completely uncontroversial, we would say, proposition. Over the page on paragraph 132, the judge refers to a submission from Mr. McCaughrean, which is that a distinction can be seen in authorities between cases in which the court has held a fiduciary duty arises out of an existing contractual relationship, as an instance of the contract between the parties, in cases in which a party is held to a fiduciary duty to the other party in the negotiation of the contract. And then he relies on what Lord Walker had said in the court case. And then this is the important proposition, again stating the orthodoxy. Below the quotation, second sentence, parties negotiated for a contract are normally entitled to act in their own interests and are not obliged to have regard to the interests of the other party, and it takes particular circumstances before fiduciary duties are to be imposed on them. Mr. McCaughrean said that in the case of negotiations for a joint venture, such cases are very rare. The only example he'd found being a case called Murad. The full title of the case, in fact, appears 2 pages earlier. It's a case called Murad versus Al-Sarraj, 2004 EWAC 1235 Chancery. And the facts are summarised there, and in the words of Mr. Justice Etherton, as he then was, the reason for the fiduciary duty being imposed was that one party was wholly dependent on the other for advice and recommendation, negotiations and instruction of professionals on their behalf. So it's a completely different situation to an arm's length commercial negotiation which we're involved in. And then, for completeness, at the top of page 133, the judge has referred to one other case, the case of Longstaff and Birtles, but then says that is a case in where the defendants have formally acted as solicitors to the claimants. The relationship between being one of solicitor and client was undoubtedly a fiduciary one, which gave rise to a relationship of trust and confidence. And the basis of the Court of Appeal's decision was that relationship of trust and confidence did not cease on termination of the retainer. See Lord Justice Nunbury at 35. So, my Lord, in this relatively recent decision, it's 2018, two cases in English legal history appear to have been identified of duties being owed by one, fiduciary duties being owed by one commercial contracting party to another in the course of negotiation. And we say, therefore, when the judge said in his judgment that no fiduciary duty could be owed in this case, he was quite right and was giving an analysis which was entirely orthodox. And we say there is no reason with respect to my learned friend Mr. Fenwick to deviate from that position in light of the submissions which he has made. That, my lady, my lords, is what I intended to say about the issue of fiduciary duty. If I may then turn again and hopefully refer to a useful authority to the issue of the contractual duty of good faith, which is, of course, the alternative way in which MRL puts its case on ground 2. And before I turn to the authority, if I may identify 3 features of MRL's case on good faith, which we say are very problematic for them. First of all, MRL says that by the exchange of emails on the 22nd of May 2014, the so-called exclusivity agreement, a contractual duty of good faith is owed by Bonhams to MRL. And as my Lord Justice Phillips pointed out yesterday, and also today, and which we respectfully endorse, this is in fact a non sequitur. Why should a duty of good faith be owed on account of a duty of exclusivity? If we assume against myself that there is a contractual duty of exclusivity, it doesn't give rise to a duty of good faith. It's simply a non sequitur. But that's the pleaded case we have to meet. Second feature is it is said that this duty of good faith was owed by Bonhams to MRL whilst they were negotiating a transaction which would become the commercial agreement. So it is a duty alleged to be owed in the course of a commercial negotiation. And here we respectfully endorse what my Lord Justice Arnold said yesterday when he asked the question of Mr. Fenwick, is that isn't the objection the same as the one to fiduciary duty? You were negotiating with a commercial contractual counterparty, so your interests are reverse. So how could this duty of good faith be owed, if I may paraphrase much more inelegantly than my noble lord? When we say that hasn't been answered, that's another fatal problem with this case. And the third is it is said that by MRL that the breach was by Bonhams not agreeing to purchase the collection of cars itself, and instead by Lohomij loaning money to MRL. It is said that the breach would lay in not making a particular type of agreement. I don't want to fall into the same error I made 20 minutes ago, confusing whether a duty is owed and whether a duty is breached. But the reason I refer to it is this is what gives flesh to the bones of that tiny sentence which Mr. Clayton took you to in their pleading, which says a contractual duty of good faith is owed. There's no pleading as to the content of that duty, but we can detect what MRL are suggesting as the content of the duty, because they're suggesting that ultimately the content of that duty required Bonhams to negotiate a particular type of contract with MRL. And then we respectfully endorse what my Lord Justice, Lord Phillips, said yesterday, which was, Lord Justice Phillips said yesterday, apologise, isn't this just an agreement to agree? Isn't the content of their contractual duty actually said to be that they should be seeking to agree a contract? And we know that's wrong because of the decision in Walford and Miles, which Mr. Gledhill took the court to this morning, and also which appears in the judgment of the learned judge below, and is not the subject of any challenge. That's not been challenged. So we say that there are these three preliminary problems, which each one would be insurmountable, but altogether means that this is really a case which has no substance or prospect of success at all. It is genuinely an arguable case. Now, it may assist because this position has actually been considered relatively recently by another judge in a very detailed judgment by then Mr. Andrew Henshaw QC, I think must have been relatively shortly before his appointment. And that is a case called Astra Asset Management UK Limited versus the Co-op Bank. And it's in the Authorities Bundle, Volume 1 at tab 2. I may ask the court please to turn that up. And we say that this decision is particularly helpful on really the first problem which I sought to highlight, which is, can a duty, implied duty of good faith, arise out of an exclusivity agreement? Because this is a case dealing with an actual exclusivity agreement, one in which there's no doubt that there was an exclusivity agreement made, and the question which the court wrestled with is, could there be an implied duty of good faith in that agreement, amongst other claims? Now, the facts of the case are relatively complicated, but if I may summarise them in this way. The bank, the Co-op Bank, wished to sell a bundle of certain debts and security interests that the bank held under a facility agreement with a borrower, one of its customers. The claimant, in this case, Astra Asset Management, was interested in bidding for those rights. The bank entered into a written exclusivity agreement with Astra, giving Astra a 15 business day period of exclusivity, during which Astra could conduct due diligence and the bank would not offer the rights to anyone else. So a conventional lockout agreement, we know, binding and enforceable. See Walford and Miles, the passage at the end of the judgment which Mr. Gledhill helpfully referred to this morning. The exclusivity agreement recorded in a recital that the buyer and seller intended to enter into the transaction subject to contract. So there's reference to subject to contract, similar to our case. There's reference to a defined transaction, so it's in that respect an a fortiori case to our one. And another recital provided that the buyer and seller are entering into this agreement in good faith and are relying on its terms. And essentially what happened, there was then a further exclusivity agreement which extended the period of exclusivity. And essentially what happened was, during the period of exclusivity, the rights, this package of debt and security interest, became more valuable. And they became more valuable because of the debt which formed part of the rights was secured by a legal charge over a development site in Leeds. Another creditor, Standard Life, had rights over that site, and Standard Life agreed to relinquish its rights. So the consequence is that the debt became more valuable because the security had improved. But when the rights became more valuable, the bank was less cooperative than its name and said it needed to reconsider the price that it was asking for those rights, and this led to the end of the negotiations. And Astra, who were very upset with the position, perhaps not necessarily unjustifiably, as they had been heavily involved in seeking to get Standard Life to give up its rights, alleged that there was a breach of an express obligation of good faith, and breach of an implied term of good faith in the exclusivity agreement. The judge, having considered those claims, held that those claims were unarguable. Now, if I could pick up the judgment, please, at page 42, the numbers in the bottom in the middle, paragraph 108, there's a heading E, Astra's good faith claim. It says Astra's first alternative case is that on the proper construction of EA2, that's EA2 is exclusivity agreement 2, and or by an implied term that the parties agreed that they would negotiate in good faith to conclude the transaction for £900,000. And it was a breach of that duty for the bank not to complete it for the price agreed on the basis that Astra had solved the standard life problem. That is, Astra had managed to persuade the competing creditor to give up its claim over the land. And so pausing there, this is rather analogous to our case because the allegation is about completing a specific particular type of transaction. Here, it's a defined transaction with a defined price. In our case, of course, it's alleged that there was an agreement to enter into a sale rather than a loan. And we then go to paragraph 114, and it's referring to recital C. And we can see recital C is just below 110. It's the buyer and the seller are entering into this agreement in good faith and are relying on its terms. And in Mr. Fenwick's submissions yesterday, he did make an observation in relation to good faith and said there was an assertion of good faith. So again, we do think that this is of some assistance and relevance in this case. And what the learned judge says is to construe recital C in the way Astra suggests would make it inconsistent with the subject to contract basis on which recital A made clear the parties were proceeding. As the Court of Appeal said in the case called Generated Developments, by negotiating subject to contract, the parties took the commercial risk that one or other of them might back out of the proposed transaction. Negotiating on a subject to contract basis meant that either party could walk away at any point until a deal were concluded. For instance, both EAs referred to the fact that Astra was carrying out due diligence, which of course is our case, the due diligence being expressly referred to in my client Mr. McLean's email, where he refers to wishing to be provided with the opinions for, amongst other things, Eversheds in Milan, and it being envisaged that there would be a due diligence process. And then a response from Mr. Walmsley, and Mr. Walmsley specifically mentions due diligence in his response. Judge goes on in this case, the outcome of that exercise might have resulted in Astra wishing to walk away from the proposed transaction or to negotiate a lower price. By negotiating to subject to contract, Astra retained the ability to do so without having to justify its decision by reference to a non-predictable good faith standard. So, Judge here has given a very good reason, we would respectfully suggest, why once one negotiates on a subject to contract basis, a contractual duty of good faith should not be owed. Of course, as Mr. Gledhill pointed out, the word subject to contract are in fact used twice by my client in his 22nd of May 2014 email. Judge goes on, paragraph 115. Fourthly, clause 3 of EA2 provided that Astra could terminate the agreement with immediate effect by giving written notice to the bank. That provision is wholly compatible with a mutual obligation upon the parties to negotiate in good faith. To conclude a contract at the price of $900,000, nor is it conceivable, and Astra does not allege that recital C imposed a unilateral obligation on the bank to negotiate in good faith. Well, of course, in our case as well, there's nothing to stop either MRL or Bonhams walking away from the negotiation in which they're engaged. There's no restriction on that at all. All they're agreeing is alleged by way of the 22nd of May 2014 emails is to negotiate during a period in which there cannot be negotiations between MRL and any other party. There's nothing to stop MRL deciding that it no longer wishes to be part of that arrangement. There's certainly nothing to stop Bonhams saying that it wishes no longer to be part of that arrangement. And that would be entirely inconsistent with the due diligence obligation, which of course allows one to investigate the transaction, discover what it's really about, and then walk away. paragraph 116 then says, fifthly, to construe recital C as Astra suggests will also make it inconsistent with the A2 clause 4, quotes the clause. The upshot is the bank could, by reason of that clause, without breaching EA2, seek to alter the price or decide not to proceed with the transaction. Again, essentially the same point as paragraph 115, which is that it can be in a commercial negotiation, a party can alter the price, a party can decide not to proceed. And this may remind one of the quotation from Walford and Miles, which Mr. Gledhill helpfully addressed earlier, where it is said in terms that in a negotiation, of course, a party may wish to withdraw in order to see whether the other party offers better, improved terms. That's part of a negotiation, and it's a reason why in English law you can't have an enforceable agreement to agree. So again, we say that's entirely orthodox and applies to our case. My lady, I noticed the time. I do have a little bit more to do with this case, so I'm entirely in my lady's hands as to whether we'd rather rise or whether I should keep the voice suspense.
It seems to me that this is an appropriate moment, and so we'll resume at 2 o'clock. Thank you very much.